All right, looks like Matt put us on YouTube, and then as soon as the attendees start ticking up there, I'll give some intros and things.
Okay.
Beautiful.
You open up.
All right, David, I'm starting and then I'm leaving.
Okay, thanks, Matt. And then Darcy, we had said I'll just kind of go around and introduce everybody, but if you want to give a brief self-bio, that would be really helpful at whenever the time comes.
Okay,
Thanks.
sure.
And you open up the chat, right?
Yeah, sure. Let me do that if
Okay.
I can. All right. Good evening, those of you joining us. Welcome to our Renter Town Hall this evening from Renters Alliance with our special guests from Maryland Legal Aid. We're going to let people join here for a couple minutes, and then we will get started shortly. But thank you for being here. And let me fix the chat. Let's see. It should be good if you want to try, Malek. Okay. Brilliant. We even had an attendee test it here. Thank you. Cool.
Fantastic. It worked.
That is working. That's where we'll be doing questions. So that's good. As more people come in, hello and welcome. We'll be getting started shortly. You're at the Renters Alliance Renter Town Hall. Thank you for being here this evening. We're going to just give people a couple more minutes to trickle in, and then we will begin. All right, I see a couple more people have joined. Hello, we'll be starting shortly. Thank you for joining the Renter Town Hall this evening. About one more minute, we'll get started. Okay, I was waiting for that. There it is. The magic number has been reached. Okay, we can begin.
Beautiful.
Thank you again for joining us this evening. This is the Renters Alliance. This is one of our renter town halls that we have normally about every other Wednesday evening or so. And so yeah, thank you for being here. I want to before we kind of begin with tonight's main program, which is we have some guests from Maryland Legal Aid here with us. I do just want to review a couple kind of just basics about the format and then just a couple quick notes generally about Renters Alliance and things. But yeah, so again, thank you. I'm here joined this evening by my fellow staff members at Renters Alliance. Ms. Pat Beckham is with us. Emily Towie is here, and Melek Demir and Tim Huang are all with us this evening. And they're going to be helping out, with questions and comments of their own, but also going to be monitoring the chat, because we would appreciate if that is where y'all direct your questions as they come up. We're probably going to, get some information out from our guests first, but we are definitely going to have time for questions. So please, if you'll put those in the chat, then our staff can bring them up and address them. If you put them in the Q&A, we'll try to see them. But yeah, if you can keep them over here. And then we'll let everyone know this is being live streamed on YouTube, so please be aware of that. And it will be available there also afterward for viewing. Let me make sure I'm not leaving any other ground rules out. And I want to just, before I introduce our guests, I will just mention that, like I said, we do. I think that's it. I think we have these frequently, normally kind of every other week or so. Our next one is, I believe, November 8th, which is a Wednesday. Yeah, Wednesday, November 8th, again at 7 p.m. And the focus at that one will be fire safety, I believe. So feel free to join us for that. But this evening, our focus is on the kind of know your rights as a tenant. And then also as it ties in with what's called the Access to Counsel in Evictions program, the ACE program, which is something that the Maryland Legal Aid Bureau, where our guests are from, are part of, along with some other legal partners, CASA and the Homeless Persons Representation Project, or HPRP. And then some community organizations like the Renters Alliance have been tapped to help with the outreach and just letting people know that the program exists, which we are trying to do this evening here some. And so that's kind of what we're going to be focusing on. And so we're really pleased, excuse me, to have joining us two attorneys tonight from Legal Aid Bureau of Maryland. And so we have Mr. Darcy Flynn with us this evening, and Jack Slattery.
Hi, everybody.
And yeah, we appreciate so much your time. We do, because we know how many people we're telling to call y'all, so we know how busy y'all are, and it is just it's no small deal that you come here and do this for us. But yeah, hopefully we can get some good basic info out as far as renters' rights here tonight, and let people know how to access the lawyers if and when it becomes necessary. And so then, just before I pass it over to y'all, if you could just maybe introduce yourselves, and I know you have a slide deck to share, but I did just want to mention again that the Access to Counsel and Evictions program is it's been funded now by the state government, and so it is active and up and running, and that means that there are attorneys from the aforementioned nonprofit legal service organizations down at the courts for failure to pay rent court, and often for the other processes too. They're available. They try to make an announcement ahead of time that, hey, we're here, but people need to ask them for the help, and so step one is knowing that they're there. But that is up and running, and but then there are also times that you can contact them for work with tenants as a group, or then excuse me, individual casework leading up to or beyond court, and we'll let them get into that tonight. So thank you again for being here, and if it's okay, Jack, I'll pass it over to you and
Sure.
Intros.
Absolutely.
Great.
My name is Jack Slattery. I'm a staff attorney. I do ACE, Access to Counsel and Evictions, full-time at Maryland Legal Aid. I've been practicing law for about 2.5 years. I went to Emory Law down in Atlanta, where I practiced housing law after I graduated. I did more housing in Texas, as well as criminal and family law. And I'm back in Montgomery County, where I'm a native. And I've been practicing with Maryland Legal Aid for the better part of this year, and working with Darcy, my colleague here.
Right. Hi, everybody. I'm Darcy Flynn, originally from Michigan. I moved to DC a long time ago, worked in the federal government, retired, and in retirement, I've continued to work. And Maryland Legal Aid has been by far the best job I've done in retirement. And I'm really enjoying learning what I'm learning and helping the clients we help. We do, landlord-tenant court. Like Jack, I do this full-time, the ACE program. And the ACE program basically provides free legal services to those who qualify income-wise. And at some point, I'll give you our intake phone number. So if anyone thinks you might have a landlord-tenant issue, you can call our intake line to see if we can help you out. But yeah, we help tenants facing evictions, and that's what we do for a career, and it's a very rewarding work.
And just piggybacking off what Darcy said and what David said as well, as a resident of the state of Maryland, you do have a right to counsel if you're facing an eviction, any kind of eviction process. And we are there, either ourselves or CASA or MHRP. Every single day there's a docket, but it's much more efficient. Your rights to counsel are much more efficiently exercised if you try and get in touch with us ahead of time. If you call intake, if you speak to an attorney before your hearing, give yourself time to put together a defense, put together evidence. We do what we can on the same day, but it's not the best way to go about exercising all of your rights as a tenant. So if you know that you have a hearing coming down the pipe, if you have that yellow complaint, call our intake line, get yourself connected with an attorney as soon as possible, because that's gives you the best odds of having as thorough a defense as possible. Now we do have a PowerPoint that I'm going to share with you guys. Just an overview of your rights as a tenant.
Go for
And
it.
after that, we're going to take some questions if that's all right with everybody. But yep, in brief, Housing Law 101, here we go. I was trying to think of the best opening story to kind of kick off this presentation, but I do think for the average tenant facing any kind of eviction action, the best story here is the fact that we get cases dismissed on a daily basis in bulk because of on the basis of the rights we're going to be talking about in this presentation. I can't tell you how many times we've had cases dismissed because of issues with the landlord's license, with issues with the notice that your landlord has given you in terms of when you have to leave and why, and when your court hearing is. As a tenant, there aren't a lot of tools in your legal toolbox, but one of the best ones is the fact that landlords very often make mistakes. They're not crossing their T's, they're not dotting their I's. That's one of the reasons that we clash with them so often, but the way it works in your benefit is the fact that very often, if you know your rights, you can use those rights to have your case dismissed, to have it refiled, to get yourself continuances, because they don't expect you to know these rights and they don't expect you to put up a fight. And very often they fold very quickly. So it's good to know what we're going to be talking about today, because they're small tools that can go a long way. And well, I didn't mean to. Starting on that, I mean, the best thing to start off knowing is the obligations of your landlords. I have to really stop doing that. And the largest source of their obligation is compliance with federal, state, and local laws. Montgomery County has its own set of pretty rigorous laws that govern how your landlords have to treat you. They're in the county code in chapter 29. It's always good to know where those are. Take a look. The Maryland Code, Real Property Act, also offers a lot of other rules that landlords need to follow. And if they don't, you have grounds to push back when they're bringing these eviction actions against you. Some of the more salient parts of those obligations are, as the slideshow overviews, you need to have a name and contact number for someone who can respond to emergencies and who's available at all times. They are obligated to provide you with a copy of the landlord tenant handbook, which is basically just an overview of some of the bigger parts of landlord tenant law in Maryland and Montgomery County. They are also obliged to, well, we're going to get to that in your rights as opposed to their obligations. As a tenant, you have obligations too. You have to pay the rent according to your lease agreement. You need to keep the properties clean and sanitary, which obviously is subjective, but I mean, use your best judgment there. If your landlord gives you proper notice, which is 24 hours to make repairs, you have to let them in. If they give you proper notice to have someone from the DHCA come and do an inspection, and oftentimes these are inspections that you probably have asked for through a complaint through the DHCA, or through the county or through the Office of Landlord Tenant Affairs with proper notice, 72 hours. You have to let them in. You have to comply with all provisions contained in the rental agreement. We can revisit that later, but just adhering to the contract that you signed with your landlord, it gives them fewer grounds to bring an eviction action against you. And this is an obligation and a right kind of mixed into one. Calling the county to lodge complaints if the landlord's not doing what they're supposed to be doing, especially when it comes to repairs, and especially when it comes to repairs that threaten your health or safety. And sort of the inverse of these right or obligations you have as tenants are a set of rights, which you have the right to read your lease before you sign it, and that includes new leases that your landlord gives you after your old lease runs out. They need to provide you with a copy of the lease agreement at any time, which can be very important when they start bringing complaints to your door and trying to evict you based on breaches of that lease. You have the right to receive a 90-day notice for any kind of rent increase. You have the right to move after providing 30 days notice. And again, you have resources, options by contacting the Office of Landlord Tenant Affairs, which we affectionately call OLTA, in order to be debriefed of your rights, to lodge complaints, and to understand what your options are when it comes to negotiating with your landlord. Darcy, you want to take them through the helpful hints?
You bet. So yeah, you know, a lot of these we've all probably been through. It's a good idea to take pictures at the beginning of your tenancy. Definitely, renter's insurance is a great idea. It's very inexpensive. When you leave the property, you definitely want to do a final inspection with your landlord. E-property data mining is a tool for searching for the conditions and the history of the property. Just a way to look up, you know, potential rental properties.
Yeah, some of the best work you can do for yourself happens before you even sign the lease. So getting to licensing, almost always, usually, but really almost always, a landlord is required to have a license to rent out
Right.
their property. Pardon?
No, I said right. Yep.
Oh, cool. Yeah, he's giving me Darcy's giving me some affirmation here.
Yeah, exactly.
One exception is when a landlord rents out a room in his or her personal residence. So if you live in a house that your landlord owns and they live there and you rent a room, they don't need to have a rental license. Another iteration of this is if you live somewhere and your landlord's relative, their child, their adult child, their spouse, their adult child spouse, I mean, it's pretty broad. If they live in a room of a property that your landlord owns, your landlord does not need to have a rental license. And just as a heads up, this situation where your landlord lives with you or your landlord's relative lives with you, it does not only exempt them from needing a rental license, it exempts them from a lot of requirements and protections outlined in the Montgomery County Code that govern most landlord and tenants. So if that's your situation, or if you find yourself approaching that kind of a situation, if someone offers you to rent a room in a house that they own, be wary of that, because it really relaxes a lot of the obligations of the landlord and a lot of protections of the tenant. And we've been kind of finding that out the hard way.
I'll just add quickly that this license issue is huge. This is one of our common defenses when we do failure to pay rent cases.
Absolutely.
Landlord takes you to court because you haven't paid your rent. If they're not licensed, case will be dismissed. Jack and I do this all the time. So
All the time.
yeah, so this isn't just something the landlord has to do and there's no consequence to it. There's a huge consequence if they take a tenant to court and it's discovered that there's no license.
And it's good for you to be aware of your landlord's licensing status, because for every month that your landlord does not have a license, you do not have to pay them rent, and they cannot come and collect rent from you. However, if you do pay them rent, you can't get it back, even if they weren't licensed. So it's good to keep an eye on your landlord's licensing status and when it expires, and to take steps to find out when it began. Because again, those periods where they're unlicensed, they can, as Darcy said, they have very serious consequences. And as I'm sure you guys all know, it can be difficult to find serious consequences for your landlord. Just more tips in terms of when it comes to security deposits and just leaving your property in general. What you're asked for in a security deposit cannot exceed 2 months rent. And the landlord needs to maintain it properly. They need to keep your security deposit in an account separate from their own personal checking accounts. They can't mix it up with their own money. It needs to be in its own account. And you're also entitled to the interest it accrues, which is not particularly significant a lot of the time if you're there for 1 year, 2 years. But I had a neighbor who moved out of her apartment this month after living there for 25 years, and the interest was significant, and it's not something a landlord will ever offer you. So it's something that it really behooves you to know about because it can be useful.
And I'll just add, this is one where Maryland Legal Aid doesn't really get involved. We would refer you to the, what Jack mentioned earlier, ALTA, Office of Landlord Tenant Affairs. They work all the time helping landlords and tenants work out security deposit issues, but we don't really get involved in that.
Absolutely, absolutely. And just keep in mind when you leave your apartment, obviously it's good to clean and inspect and make any record of maybe damage that was there when you moved in, just to remind the landlord that it's not a product of your tenancy in the property. And also remember that if a landlord refuses to give you back your security deposit or deducts from your security deposit, they need to, one, tell you within 30 days, and two, they need to give you an itemized outline of every deduction and the reason why. And when you have that, that's where you can start negotiating with them or arguing with them, because a lot of them don't expect you to look. A lot of them don't really expect you to put up any kind of an argument, and they can really get away. I've seen landlords walk away with a lot of security deposit pretty easily. So don't make it easier for them. Let's see. Notice. So notice, as much as licensing is a frequent defense for our tenants, problems with the notice that you're entitled to before major changes or actions for eviction is another very common defense. And actually, Darcy, you want to walk us through this one?
Absolutely. So the license is a huge issue. Notice is another way we get cases dismissed all the time in any type of case, not just failure to pay rent, but failure to pay rent, breach of lease, tenant holding over, which means your lease is up and the landlord wants you out. In all of these cases, they're required to provide written notice. And it varies on how long the notice needs to be. For failure to pay rent, it's 10 days. For breach of lease, it's anywhere from 14 to 30 days. For tenant holding over, it's typically 30 days, sometimes 60. So there's a notice requirement, and we find landlords routinely, especially when they're not represented by attorneys, routinely don't understand the rules. And like Judge Williams in Montgomery County says, if you want to be a landlord, you got to either, learn the rules. And
Absolutely.
A lot of them don't. A lot of them don't. So this is if you receive a notice from your landlord that they want to terminate your lease, it's good to know what is required in that notice and that they're doing it properly.
Absolutely.
Otherwise, it's a basis for getting your case dismissed.
And included in this slide, and this is kind of, again, sort of a reversal, it's notice required from the tenant to the landlord, and that has to do with notice of defects, asking your landlord for repairs, telling your landlord that you have cockroaches, or there's a rodent infestation, or there's water damage, or what have you. Your landlord is obligated to fix these things, but you are obligated to put them on notice that these repairs need to be made. And if you show up to court and say, I have cockroaches, I have rats, I have water damage, the ceiling's caving in, if you don't have a written record, maybe an email or a text or something of you notifying your landlord that these repairs need to be made, it's very easy for your landlord to just claim ignorance. And legally, they are entitled to notice. And I mean, just sort of on an off note here, I would do the same, not just in terms of notifying your landlord of defects, but notifying the county of defects, notifying the Office of Landlord Tenant Affairs of defects. The more you have complaints on the record, the more of a foothold you have in the legal process when it comes to going to court for eviction actions that are being brought against you. The more that you can point to written evidence that you made complaints to your landlord or made complaints to the county, the more of a foundation it gives your defense when push comes to shove in these hearings. So I would never hesitate in doing either of those things. Um, I have everything in
Great.
front of me.
This is great info so far. Y'all, thank you. I just want, I mean, I don't know if you're noting, we do have a few questions kind of coming in. I just didn't know if you want to go ahead and get through the whole deck first, or if some
Oh,
of them
that's
are
all
on-
right.
wanna
Let's
break
take the,
in?
we can take the questions.
Sure,
No
let's take a
problem.
question.
Okay, only just because some of them, you were just on the notice and there was a couple notice questions from before. Just about someone had asked, that thought a slide said a tenant needs to give 30 days if they're gonna move out. But then we have a couple questions that looks like the landlord put in the lease that they're requiring 60 days from the tenant to give notice if they want to
I might
move.
have misread that slide, actually. I think it was moving out in for repairs. Um,
Oh, okay.
in
Well, yeah,
terms of the
if you're
notice you need to give your
wondering-
landlord to move out, if you're in a month-to-month tenancy, yeah, it is actually 60 days. I apologize. I misspoke.
No, that's fine. So that's on that end. And then is it the other way as well? A notice to vacate at the end of a lease from the landlord then is 60 the other way too?
It's absolutely at 60 days. And as Darcy was saying, a lot of times landlords, especially landlords who are sort of running it on their own, they don't have, a big law firm sort of showing them how to do all this stuff. They make mistakes there too. They don't give a written notice, or maybe they'll give you a written notice for 60 that you have to leave in 60 days, but they'll file the case for your eviction after 45 days. Because maybe it becomes clear to them, so they think that you're not actually leaving. They need to, not only do you need the notice, but they have to wait 60 days before filing.
If I can just add, here it gets nuanced. So I had a case dismissed because the landlord said that they mailed the notice, first class mail. They didn't realize that when you do that, it has to be certified. And they also said they emailed the notice to the tenant, which is fine as long as the lease provides that the tenant will agree to that. And they didn't have the lease to show that. And so the notice, there are various nuances with the notice requirements for landlords that they often get wrong.
Thank you.
Absolutely. And this slide actually kind of dovetails with both of these questions. After your lease ends, your tenancy changes to what's called a month-to-month tenancy. So you're not locked in for a year, your landlord's not locked in for a year. However, if either of you if either you want to leave or your landlord wants you to leave, you need a 2-month notice before that action can even begin. So that's good to keep in mind.
And if I can just tag on to what Jack just said, if the landlord wants to end your lease because it has become a month-to-month lease and you don't want it to end, it is very hard to defend a tenant holding over case. Ultimately, in Maryland, the landlord doesn't need a reason to want their unit back. They can simply say, you know what, your lease is up, I want my unit back, and that's it. However, having said that, there are, again, some defenses. License is not a defense, but notice is. They have to give proper notice. 2 other ones I'll mention. One is the plaintiff on the complaint needs to be the owner of the property, and they often get that wrong. They'll often have the property manager put their name down as the plaintiff, so that's incorrect. Also, whenever it's a corporate landlord, which usually it is, they have to be in good standing with the Maryland business registration, and they often aren't. They don't pay their taxes, their annual registration fee. They fall into forfeited status. That, again, is a very good way to get a tenant holding over case dismissed, which will at least buy you more time to move on. But ultimately, with a tenant holding over, if a landlord wants their unit back, they're ultimately going to get it.
That's true. And I would also say I'm sort of hearing myself talk now, and I know that this can maybe sound a little pie in the sky, in the weeds, complicated, but that's just another good reason to, when you get notification that you're facing an eviction action, to call intake either at our organization or with CASA or the HPRP, because these are, just because you have you get one of these notifications, you get this notice and it's terrifying and it says you have to leave. But there are lots of different small things that could be wrong with it that could buy you more time. So instead of kind of giving up or just assuming that you just got to go and do whatever the landlord tells you or whatever the judge tells you, you have resources in us, as well as these other organizations, and you should use them because these situations are often a lot less hopeless than they might feel when you first receive these eviction notices.
Darcy, on the just a quick thing, our understanding is to piggyback on this whole many nuances, definitely good idea to call the lawyer thing. Some properties, if they're like a tax credit property or maybe HOC owns the property, they do need actually to have a good reason to do it.
That's exactly right. And I was contemplating whether I should jump into that topic. So on the subject of tenant holding over and a landlord ultimately getting their property back if they want it, there's an exception, and that's subsidized housing. HOC, if you are an HOC tenant or contemplating becoming one, you have elevated rights. In order to terminate a lease with a subsidized tenant, there has to be good cause. Now, good cause can be things like repeated failure to pay rent, or other good reasons. This ties in with breach. There's another type of case. There's failure to pay rent cases, there's tenant holding over cases, and there's breach of lease cases. And in breach of lease cases, the landlord saying, you breached the lease, you violated some terms, we want you out. And those are the types of things that a tenant has to have done in order for a landlord to not renew the lease. So yeah, with subsidized housing, it's an exception to the general rule of tenant holding over not needing a good cause. Yeah.
Okay. And is there, I mean, like another edge to that sword? Well, not necessarily, maybe it's not necessarily bad, but we had some questions about requirements for recertification that may, apply to some of those tenants versus, that come along with renewal. But we also hear that sometimes the subsidized housing has their own kind of code enforcement that comes in before the county. Are there any kind of maybe best practices for folks that, do you encourage folks in the situations to go ahead and do an intake if they're just confused about the entities and things? And
yeah, let me give you the number now. The Maryland Legal Aid intake line is 888-465-2468. I'll repeat it, 888-465-2468. If you're a tenant, even if you think you might not qualify financially, it never hurts to call the line. If we can't help you because of income limits or anything else, oftentimes we can refer you to someone who might be able to help you. So it's well worth making that call. Just tell the intake person what your legal situation is, your housing situation, and they can help. But I will say real quick, in the subsidized housing area, there's two different major types. One is a low-income housing tax credit property, a LTSI property, which is we also called a project-based voucher, where that unit itself is subsidized. If you leave that unit, the subsidy doesn't follow you. The other is a tenant-based voucher, where you can move from unit to unit and bring your voucher with you. Those LTSI properties, those project-based voucher units have an even more elevated benefit, and that is if you're being threatened with eviction for either tenant holding over or breach of lease, not only is there a good cause requirement, but you can always demand a jury trial. That buys you an extra year, and it often dissuades the landlord from paying an attorney to go through that process.
Right. Okay. You touched on another question though that we had just then a second ago when you said if someone doesn't qualify by income. You did have someone asking, what are kind of the income requirements for y'all's services? Or I don't know if they're asking for the ACE program in general or legal aid, if those are the same.
Yeah, they are the same for legal aid and the ACE program. It is the income requirements are a function of your total household income and how many dependents you have in your household. I couldn't really rattle off any numbers for you right now. But if you qualify, for example, if you qualify for subsidized housing subsidies, you almost certainly qualify for our services. And if you don't qualify for housing subsidies, that doesn't necessarily mean that you don't qualify for our services. It's just a nice rule of thumb.
Yeah,
But it's almost certainly worth it just to call, go through intake and see if you qualify.
I think it might be 125% of the federal poverty line. And I can give you a couple of examples. I had a case today where it was a married couple making about $3,000 a month, and they just qualified. No children. If you have children, your income can be higher and you'll still qualify. And if you are seniors or disabled, that allows for higher income as well. But I know a married couple today made about $3,000 a month, and they were right on they qualified.
Well, that's just a helpful example. Thank you. And yeah, much like we tell people who, when they're asking us about the county programs, even if we have the chart in front of us, often it's still worth talking to the person that's actually doing the income calculation. Everyone has their own methods and things. So, no, and then especially with what you mentioned about possible referrals to like low bono or private attorneys, if not, seems worth reaching out anyway. So that's great. Thank you.
Absolutely.
Another thing real quick. So Maryland Legal Aid has a citizenship requirement. You have to be a citizen or have a work permit and a few other exceptions. Whereas CASA, I'm pretty sure, will work with undocumented people, no problem. And so we have different requirements at the sister agencies. So we will often refer someone to CASA if they otherwise qualify financially, but maybe they're not a citizen or have work papers. So that's another good reason to call Maryland Legal Aid, is if we can't help you, we can hopefully refer you to someone who might be able to.
Absolutely. I'd love to get to individual questions, but we can just sort of wrap up the broader points of your rights. I'm sure if any of you have had experience with housing court or with actions brought for eviction, it's probably been centered on a failure to pay rent. So a couple of basic things to remember: if you receive a yellow complaint saying that you failed to pay rent and they're bringing an eviction action against you, you must have received 10 days before a written notice. It's a notice of intent to evict, or an NOI, saying that your landlord is going to file a lawsuit against you in 10 days. If you don't receive that, it's not proper notice and your case is dismissible on its face. And also, I would just say that notice of intent to evict for 10 days, the yellow complaint you get on your door saying you have a court date, those are not eviction notices. They don't mean that you have to leave. Your landlord, a lot of landlords will leave other kinds of notes on your door, will write you certain kinds of letters, will say that you have to leave, that you're in immediate danger of being evicted by the sheriff, all sorts of things I've seen. That's not legal. And you cannot be evicted unless you have gone through a legal process, unless you've been given a court date and ideally shown up to that court date. But if they want to evict you, you have an opportunity to go to court that they can't take away. So that's just something to keep in mind, because I know how panic-inducing these complaints can be, these notices. And sort of kind of as a corollary to that, you do have the right to be heard in court, but you forfeit that if you don't show up. So never not show up, no matter what your landlord tells you. We've had so many clients who had their landlords tell them that actually they dropped the case, or that it was resolved one way or another, that they don't have to come to court. And the reason your landlord is interested in telling you that is that if you're not in court, your landlord wins automatically. And it's just always in your best interest to show up on the date that you're told to show up to court. It is also in your best interest to show up on time, or even before the time that you have been scheduled to go to court, for a lot of reasons. The biggest one is it gives you more opportunity to speak to ourselves or CASA or any of the other legal organizations that are there to offer you assistance. Once your hearing starts, it's like going to traffic court. You got to sit in there and you have to wait for your name. It usually takes a couple hours. And if they call your name and you're not there, even if you're not there because you're outside talking to an attorney, if the court doesn't know that, they'll just give it to the landlord right away. And we also have much more frequently people who show up an hour after the court started or a half an hour or whatever. It's very likely that your case will have been called by then, especially if it's a failure to pay rent. They do 200 plus of those in the morning, 200 plus in the afternoon. They blaze through them. The responsibility is on you to be there, to speak up when they call your name, and I mean, do everything that, exercise every right that's available to you in order to defend yourself from eviction.
Can I check, if I could just throw in a quick tidbit, because we do go down there from time to time just with some tenants. And one thing I've noticed that I do want to remind people is you can be heard if you go down. But what's jarring to me is just the summary ejectment proceeding itself, that it is very clearly a summary proceeding, meaning you're only going to be heard about the rent. And Maryland really did this fast track here, and it's a little slow only because the volume's so high in court, right? But
absolutely,
notice tenants think that they're going to have a chance to address other issues, and certainly, with Jack's help or someone, you could perhaps affirmatively bring some complaints you have, but be ready to only talk about the rent owed on that date.
Absolutely. I think, David, that's a great point. I think a lot of clients, or rather defendants, show up to their hearing thinking that this is going to be their time to tell the judge about the many, many shortcomings of their landlord. And don't get me wrong, those shortcomings, I've seen them all. They are common, they are numerous, they are often very severe. They're valid, in short. But the judge isn't interested in hearing about them, because no matter how terrible of a landlord they are, if you're there because you haven't paid rent, your only defenses there are either that you have paid rent or that you don't have to pay rent because of a licensing issue or a notice issue or what have you.
I'll add one other one real quick, Jack, and that would be if the conditions of the property really are super bad, and especially if you've got city inspectors showing up with or providing reports that it has failed inspection, then that's something that can be a defense in a failure to pay rent case. So that's something to keep in mind. But most tenants, when they come, aren't prepared enough to raise that defense.
No, and I would also say, just procedurally, if you're there for a failure to pay rent, most of the judges will ask you two questions. They'll ask you if you agree you owe rent to your landlord, and if you agree that you owe the specific amount of rent on your complaint. And most tenants will say yes to both of those questions because they think there's going to be a third question, and there's not. And the judge will just stamp your paper and be on your way. And a lot of times tenants are so eager to get into, again, like the other problems that they are having with their landlord, that they just say yes to these because that's where they think it's going somewhere. It's not. The judge's expediency is one of their priorities. I don't mean to paint them with a bad brush. A lot of judges try and assist defendants in these cases as much as they can, but that's not really their job. And a lot of times it's not really their priority. So don't rush through, show up. And I'm telling you, in Montgomery County, you can always say, I would like to talk to someone from legal aid. And they will, instead of ending your case, they will pass it. Basically, they'll pause it and let you go out to talk to one of these lawyers. So make sure that that's one of the first things you say if you do want to talk to a lawyer, especially if you maybe showed up late or didn't get a chance to talk to somebody.
Yeah, Jack mentioned some reasons to show up on time. I'll mention one other, and that simply is for these failure to pay rent cases, which are the most common ones. Oftentimes, when the court does issue that judgment against you and stamps your yellow complaint, the Montgomery County staff are sitting right outside the courtroom, often helping people pay these judgments, see if they qualify for food stamps or other benefits. But they will often pay these judgments for people and help them get back on their feet. So that's something to keep in mind if you're facing a judgment. Sometimes the county will pay it for you.
Absolutely. But in order to begin that process, you need to be there, have your complaint stamped in person by the court staff. If you just don't show up, qualifying for those payments is going to be a lot more difficult, if not impossible. And to that end, just a brief list of what you should bring to court. And slideshow is a little outdated. I don't think that there are still COVID relief concessions being made, though Darcy might be able to correct me on
No,
that.
I think you're right. I think you're right. I think
Yeah,
that
so we'll make a
needs-
mention of that. The most important thing you should bring to court is your yellow complaint. That has all the information that the judge needs. It has all the information that the landlord is obligated to provide, and if they fail to provide it, can get you a dismissal based on one of these errors that we've been discussing earlier. That is by far and away the most important thing. You should also bring your lease, just because your landlord is going to be claiming that you were supposed to do X, Y, or Z thing. That's true in a failure to pay rent. That's especially true in a breach of lease. That's true in a tenant holding over, where they're claiming that your lease was over. Maybe it's not over. Maybe it wasn't over as over when they said it was over. It's always good to have a copy of your lease. And as we said earlier, it is one of your rights as a tenant to get a copy of that lease from your landlord when you ask.
I'll reiterate. Oh, sorry, go ahead.
No, go on.
I want to reiterate what Jack said earlier as far as the benefit of contacting us in advance, not just waiting until the day of court, because there we will send you an email asking for all these documents, and it really gives us time to review your case and look for any possible defenses for you. So yeah, this is just another reason to reach out to us in advance and not just show up at court, although we will help you on same day representation also.
Another important thing is, if you believe you paid your rent, to bring receipts for those payments. You can show those to the judge. And if you've paid rent on the months that you're being, that your landlord is charging that you did not pay rent, done, dusted, that's a dismissal right there. I would also encourage you to, before your hearing, ask your landlord for a copy of your ledger. That is another right that you are entitled to as a tenant. Your landlord is obligated to keep and maintain a clear itemization of everything you owe over the entirety of your tenancy, and you have the right to see it. And that's extremely helpful when you are litigating or arguing or what have you with either your landlord or a judge about how much you owe them and when. So ask for one. If you don't have one, ask for one. If you forgot to bring one, you have a right to see it, and it's important.
And they do often make mistakes on those. So yeah.
They do.
Yeah.
The photos, video, and list of conditions, that's not as important unless you're planning on bringing a rent escrow defense, which you should probably be talking to an attorney to do in the first place. And like we said earlier, just bringing evidence of how crummy your apartment is, unless it's in certain cases, it's not going to be of real relevance to the judge. And like we were saying at the very beginning, doing a little investigation into your landlord's license status, their certifications when it comes to lead paint. That can be a defense right there. But again, that's something you probably want to talk to an attorney to help you with, because figuring out your landlord's license status, I mean, it's hard enough for us. It's hard to know where to even begin. So we recommend you talk to somebody who can maybe make that process a little more efficient.
Yeah, we have access to some websites that require subscriptions, and so
paid memberships and things like that.
Yeah.
Right, that's good to know, because we do try to guide people to e-property, and it will be very suspicious. It will tell you pending or something.
Yes.
But then we actually have had to kind of go in circles with licensing to get a clear answer from them. We're kind of hoping that maybe with the new information available after the stabilization regulations, that might be more public facing. That'd be nice, but we're hoping.
I mean, that's been our dream, David. The DHCA's website on that is very slow to update. The information they give you is very narrow. They'll tell you if your building is licensed today. Maybe it hasn't been licensed for the last 9 months, but it's licensed today, and that's all you're going to be able to know. I mean, it's difficult information to get access to.
Also, if you don't have the license number off of that complaint, if you just type in the address, I don't know about you all, but we, half the time, it doesn't give you any license history or the current license status.
Yeah.
It's hit or miss for sure.
Yeah.
So the Housing Opportunities Commission and the Department of Housing and Urban Development, those are resources, state and federal resources that provide housing subsidies to low-income tenants. If you are a subsidy recipient, that's going to factor into the eviction process, and having subsidies can give you more defenses, entitle you to more process, but it also raises the stakes, because if you fail to pay your rent, or you breach your lease, or go through an eviction process that the people providing your subsidy, like the HOC, decide disqualifies you from subsidy, that can be a big deal. So if you do receive a housing subsidy, that's another reason to come to one of our organizations, because it can entitle you to a lot of different things depending on the type of subsidy. And it also, like I said, it makes how you proceed with the eviction a lot more important. Darcy, you have anything to add to that? I know you do.
Yeah, we've worked with clients who are facing a two-pronged problem. They're being sued by the landlord, and they're being threatened with termination of their subsidy. So if you're in that position, or you know someone who is, we can help with both. Like this final bullet says, we do help people just preserve their subsidy. Sometimes we'll get a client who is not getting any bad news from the landlord, but their subsidy provider wants to terminate their subsidy, and we will get involved and try to work something out on that, in that regard. And we're usually pretty successful at doing that. Once they show up with an advocate, the subsidy providers tend to give the tenant, the utmost respect and opportunity to cure whatever the problem might be.
Mhm. Actually, Darcy, you want to keep going through the different kinds of vouchers here?
Oh, absolutely. So housing choice voucher assists with rent. And this is the tenant pays a percentage of their income, typically about a third. And the voucher is tied to the tenant. This is what I mentioned earlier. These are the typically called Section 8 or HOC voucher type situations, where the tenant receives a voucher. That voucher pays for the majority of their rent. And if the tenant wants to move to another building, they can do that. The voucher follows them. In fact, if they want to move to another part of the country, the voucher typically follows them. Obviously, tenant and landlord must both abide by the guidelines. That's what we call a tenant-based voucher.
And then, so if someone with a tenant-based voucher, just to clarify, got a notice to vacate for no reason, there would be no extra protection there, like the other.
No, they do. There's a good cause requirement for tenant-based vouchers.
Okay.
What I said earlier was, while there is a good cause requirement for both tenant-based and project-based vouchers, only the project-based voucher gets the enhanced ability to demand a jury trial.
Oh, wow. Okay. Thank you for
But
clarifying.
they both have a good cause requirement. And where that matters, so failure to pay rent is a good cause. So a lot of times landlords bring tenant holding over cases because the tenant has constantly been behind in their rent, and they want them out. And they generally are going to prevail at that. However, I have a client where the HOC pays all of the rent. So there's no dispute on the rent, but the landlord's ledger is a mess, and it claims the tenant owes thousands in utilities that they don't. So that would be one where we can challenge, you don't have a good cause here to end this tenancy. So this is the LITC, the low income housing tax credit subsidy, is where the unit itself is subsidized. These are landlords who get a federal tax credit for providing low income housing. Each unit is subsidized. So if a tenant moves into that unit, they go through an annual recertification process, and they live in that unit for as long as they want. But if they leave for any reason, that subsidy will not follow them. Whoever moves next into that unit will have a subsidized unit. So the unit itself is subsidized. That's a LITC property or a project-based voucher.
All right. And Just to sum this up, I mean, Darcy, I think you've covered this actually.
Yeah, good cause requirement, jury trial for LITSI for project-based vouchers. Yep.
So these are, this is the information for our organization, for our intake, the time we have open for walk-in intake hours. We're in Rockville down the street from the court. And you can always call through telephone intake as well. I know, David, I feel like we've gone quite a bit over time and I do apologize, but I'm happy to take as many questions as we have time for.
No, I mean, we appreciate you kind of trying to take some of the relevant ones as we went, because they were kind of stacking up. So I think we're pretty good. We leave till 8:30 usually on this, but I don't think we'll have that many. But no, I definitely have some follow-up questions, because you got the wheels turning here in a really good way with a lot of great information. But I do want to, I've been kind of asking you as we go, so I want to just check in with staff here. With other Renters Alliance staff, is there anything that y'all wanted to ask that you've been kind of waiting on, or that you from earlier, that any questions that we want to put out to start here? Because if not, I'm glad to.
No.
Not hearing any.
There was one question in the chat from a non-licensed landlord. Are they still required to provide a ledger? Yes.
That's a good question. I believe the answer is yes.
Okay.
A landlord who's not licensed and who's allowed to be not licensed, for example, someone who lives in your home or whose relative lives in your home. This sounds troubling, but they are pretty much exempt from everything in the Montgomery County Code that governs landlord-tenant relationships, all of Chapter 29. Fortunately, that's just kind of the extra stuff that Montgomery County is pretty generous enough to provide tenants in terms of rights. All of the state law applies, and that's where the real meat is. And yes, they are required to provide a ledger for you.
Thank you.
Okay, great.
I have a quick question. I have a client who is in that exact situation. Unlicensed landlord, he's renting a basement apartment, blah, 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 blah. And he will be behind his rent in November. And the landlord believes, the landlord's told him he will completely evict him and put all of his stuff out. Because of that situation, can he do that?
No, he absolutely cannot do that.
No.
No.
Self-help evictions are not allowed.
Yeah,
So
so
he
that
still needs a 10-day notice and a court summons.
it depends on why he wants to evict him.
Failure to pay rent.
Yeah, he would need a 10-day notice, and he would need to file a failure to pay rent after that 10 days, and they would
Right.
need to go to court. Yeah, that's not, I mean, that's
Not a licensing issue.
not a licensing issue at all. Or it's rather, I guess, that's not a licensing privilege that he gets to sort of sidestep because he lives there.
Okay, thank you so much.
Of course.
Yeah, landlord, that can be criminal. A landlord has to follow, the only way to evict a tenant in Montgomery County, in Maryland, is to go through the court process, serve notice, file a court case, get a judgment, and have the sheriff do the eviction.
And I would emphasize the criminality when talking to that particular landlord. That might be your best weapon there.
A couple people were asking, is there a way that they could access this PowerPoint later, or is there like a link or anything we could share with them?
We're happy to send it around. I mean, David, if we provide it to you guys or one of your staff here at the Renters Alliance, then absolutely, we'd be very happy to.
Okay, if you're willing to share it, yeah. If someone wants to put the info at Renters Alliance email into the chat, please you can reach out. So I will just remind everyone, this is going to be on YouTube as well, including all the slides. So which will be linked on the if you search Renters Alliance on YouTube. But yeah, no, that's great. Thank you for sharing.
Yeah, we might update it a little bit, and we'd be happy to share that resource for you.
Cool. All right. Okay. And I've got a couple. I'll go ahead and ask a question there, but staff, please chime in. If not, I heard at the top, something about the difference between utilities and rent, and we were talking about it's very limited what you can say when you're at a failure to pay rent. You're defending yourself at a failure to pay rent. Is one thing to say if you think that it includes utilities, in the case, and it's not just the base rent. Is that something to bring up? And if so, how are the judges treating that?
Absolutely. And that's what we mentioned earlier about a ledger. You have a right to a ledger from your landlord. And frankly, I mean, what the judges should be doing, in my opinion, they don't do it unless you bring it up. But if a landlord is claiming that they owe X, Y, or Z amount of money, they should have a ledger to substantiate that. And what a ledger will do is make clear what money is rent and what money is everything else, because you can only be evicted for failing to pay your rent. You can't be evicted for failing to pay your utilities or your trash fee or your parking or whatever else might be part of what you owe your landlord on a monthly basis. It has to be the rent, and that's very important. There's a lot of jurisprudence on it, for lack of a better term. Not to be the first guy that says jurisprudence in the town hall, but yeah, there's a lot to it. So make sure you're getting that ledger and make sure what they're charging you is the rent that's on your lease.
No, that's great. No, you had to say it at least once, or it wouldn't have-
Absolutely, get it on the books.
One thing to keep in mind too, if I may, oftentimes what we find in court is like we show up today and the complaint was filed back in June because the courts have been backed up. And so they file, I had a case today. They filed in June for the months of March, April, May, and June. What oftentimes happens is since June, the tenant has at least made some payments. If the line 8 amount on that complaint that was filed in June has been paid, even though the tenant is not current on their rent, as long as that amount has been paid, that particular case will be dismissed. The landlord would then need to file a new case for the current months, October, September, August.
Can I ask a follow-up about that? Because we've heard kind of things about if maybe because I'm hoping maybe you could provide some best practices on paying rent as just to kind of set y'all up to help tenants and to help tenants help themselves. As far as we've heard that if you just send in a payment, whether it's through an online portal or a check or something, that the landlord gets to apply it, even if it's clearly the amount for the rent and you pay it on June 1st. They get to apply it to the oldest thing in the balance. Is that even true? And how can you prevent that from happening if not?
You can prevent that from happening by marking very clearly on your rent checks or other payments the month and date literally the fact that it's rent. Make that all very clear. Rent, October 21st.
Put that memo line to use then, I guess.
Truly, exactly, because they can attribute that to your oldest debt. And a lot of times, again, this is where it gets a little convoluted with the math and why it's really important to ask for a ledger. Sometimes it'll be applied to money owed that's not even your rent. If they're suing you for unpaid rents, in July, August, September, and you also have utilities or other things you owe from those months, those might be deducted from the rent payments you make, and then you'll be short for the third month, if that makes any sense. So be very clear when you pay your rent. Yes, Sarah Katz has got it. That's some Galaxy Brain stuff. You've got to do it. Just make it really clear.
No, thank you.
Two things. In the example I cited, it would actually be beneficial for the tenant for the rent to be applied to the old, because that would at least get rid of that old complaint. Also, sure. There's the issue of late fees. There is case law that indicates that while the landlord can charge late fees, if the tenant has any payments the tenant has made cannot be applied to late fees or have to be applied to rent in determining whether the client is behind in their rent. Simply meaning the landlord can't set up a situation where in January the tenant is late and gets charged a late fee, and going forward they pay their rent on time every month, the full amount starting in February 1st, and the landlord tries to charge a late fee every month.
Wow. And I feel like we've seen ledgers that show that just that happened. One small thing happened. It was just from there. Wow. That's good to know. Thank you. Let's see. We covered the notice ones that I had. The requirement for the ledger, that's great. Did that. We had a question toward the beginning when we were talking about this being related to the access to counsel and evictions program. We did have a question about whether y'all only provide help in the eviction situation there, or if there are other situations where a lawyer can help, and specifically where y'all can. I don't know if they had someone specific. I know we've seen some stuff come up about kind of problems between tenants, and things in the chat. I know some folks have had problems with kind of intimidation tactics of maintenance just busting in without any notice, very much on purpose. And are there any times with non-eviction kind of scenarios where y'all help out, or?
So broadly speaking, no. If you're facing an issue that the consequences of the issue is your eviction, we can usually help you somehow. That
Okay.
involves subsidies you receive from the HOC, some other issues, intrapersonal tenant issues. I've seen some questions in here about noise and things like that. That's not going to be something that not only can we not help you with it, but there really isn't a legal recourse. That's just something you're gonna have to figure out on your own. That said, when it comes to the intimidation tactics you mentioned, and really just anything that comes down to your landlord acting aggressively, for lack of a better term, bullying you, breaking the rules, his obligations, or even the law, what I would strongly emphasize you to do is, if it's in writing, if it's recorded in any form, keep it. And even if it's not, call the county, call the Office of Landlord Tenant Affairs, make a complaint. Now, I'm not, oftentimes they can help you, oftentimes they cannot, but there is a defense that I don't think we have spoken about, Darcy, which is retaliation, which is
Yeah,
if your landlord is trying to evict you for any of the reasons that we've discussed today, and you can prove that in the last 6 months before they filed that action, you made a complaint to the county or to the state about your landlord, or even the retaliation law can often cover complaints you made directly to your landlord about deficiencies in your apartment or repairs you need them to make, or things that you want to change, and they reacted negatively, and now you're facing an eviction. That can be grounds. It's harder to prove, but that can be grounds for a retaliation defense as well. And if you can prove to a judge that they're retaliating against you, that they can't evict you. It really puts them in a hard spot. Even with tenant holding over, sometimes that's a little more dubious, but yeah.
It is a defense. It is a
yeah.
defense in tenant holding over. Yep.
And I mean, so the more you document those instances, it can be a very extreme increase in your protection, because that's basically since 6 months where they can't evict you.
Yeah.
I mean, don't go take that and go wild. But I'm just saying it gives you a lot of defense in an area of the law where there aren't a lot of defenses for tenants. So I would encourage you guys to do that.
It's presumed retaliatory, but the landlord can always present evidence suggesting that it wasn't done for retaliatory purposes, but it's presumed retaliatory.
Right. Well, it's encouraging to hear, mainly because, a lot of times, it's one of the properties we were talking about before the call started. Sometimes it's just that people are too afraid to make the complaint, but then, hearing that there is a bit of a lining there, even maybe potential additional protections, that's at least good to hear. In that, but that's great. Those were some of the main ones. I want to check with staff here again. And before I have two quick, little in the weeds questions I can drop before we wrap up, but fellow staff, anything else you want to elevate from that hasn't been covered yet, that's relevant? I know what I will say, just to kind of complement what you just said there. I remember y'all mentioned there's one of the tenant's rights, tenant's responsibilities is notice of defects, right? The tenant has to give notice of the defect, and that reminds me, Matt, our director, wanted us to make sure to cover that while we have legal recourse sometimes and things. You want to make sure you're going, if there is a problem with the property manager, you're going to them first and letting them know. And then if there is either no response or an unreasonable response, that's when you're just like Jack was saying, that's when you're letting landlord tenant or code enforcement know. Okay, we've got the Ulta intake email in the chat. Code enforcement, you're going to want to call 311. If you live in Gaithersburg or Rockville, it's going to be a different office. Let us know. We can help you navigate that. But then, I mean, there are legal partners here available, which again, we're very grateful for that. But just make sure you're going through those steps to, set yourself up for success, because you're gonna get asked kind of, did you let them know there was a problem and as such. There was security deposits came up, and I remember you saying that there was a issue about something with you had mentioned a notice that someone chose to mail. It had to be certified. We saw a tenant forward an Ulta complaint where it looked like that if there is a list, if they're going to keep some of the deposit, that itemized list has to come by actual mail, first class mail. And we saw a tenant trying to raise that. Has that, I know, again, this is kind of hyper specific, but we saw that. Do you know if that is a part of that notice requirement?
I have never heard of that, but you know
No,
what?
I
Not
haven't
the
either.
craziest thing I've ever heard. Why not?
Okay, I think it's going to the commission because they were disputing, so we were just curious there. But you, I think you answered all the other specific ones I had there. Great. Well, yeah. Well, thank you again for being with us here and devoting all this time to this, and then just honestly for devoting your days to this and getting the lay of the land and the courts, conveying that to us, and being there for our tenants. We've been reaching out because more and more we're encountering these unlicensed places. I'm glad that came up so much. Is there, we don't, of course, give legal advice since we're not lawyers. So we're not out here telling people not to pay rent. But if a tenant is, if they are unlicensed, then how confident, if the tenant is sure they're licensed, let's say, on the day of the rental payment, which we know we've been over, that's hard to be sure. But if they are, is it just a go ahead and don't pay thing? And then
if they're sure that they're unlicensed, yeah, absolutely. Don't pay. They can't legally collect rent from you. I would maybe hold on to that money before you can talk to an attorney. But frankly, if you can really verify that they're not licensed, they can't get that. You can't get that money back once you have it. So finding out your landlord is not licensed, and just writing that out as long as you can. I mean, that can be an enormous windfall. It can. I mean, it's a month's rent can make serious difference in all of lives. I think we all can agree on that. So, the worst they can do is ask you for it.
The applicable case, in case anyone wants to read it, is called Asana Carroll, and that's a recent case, and it held. Its predecessor was McDaniel v. Baranowski, which held that a landlord had to be licensed at the time they filed the complaint. Asana Carroll took it a step further and said a landlord cannot collect rent during any time period they were unlicensed, because getting licensed isn't just a perfunctory way to raise fees, it's a health and safety issue. And so, but I will say, not all judges are 100% on top of this relatively new law. I had this case recently and had to hand the case to the judge to let him read it for 15 minutes, and he did agree with it. So we're winning these cases, but we can't guarantee that there's not going to be a judge who maybe not be as familiar with this trend in the law and not rule in the tenant's favor. So, but that is the law, that the landlord cannot collect rent during time periods that they're not licensed.
Well, thank you for sharing the actual site with the lay people, because that's one of my favorite things. I know there's other nerds on here like me that are gonna look that up. I just got done with another banger, which was Sager, here.
That doesn't make you a nerd, David. That makes you really cool, actually. Makes you a cool guy.
There you go. Well, we know
Right.
nerds are cool, so that's good. But no, that's great. It's good to know there. And I mean, yeah, hearing you say that if it's a health and safety thing, my mind starts thinking of escrow, and yeah, you don't need to be paying to be in an unhealthy or unsafe situation. So good, and kudos to you for educating our judges one by one. That's great. But anyways, I really will cut it off now and let us finish up here 8:15. Value people's times. But thank you to our guests again. Thank you to staff. And we look forward to our next town hall November 8th. Hope everyone can join us and come out and hear about some fire safety best practices then. So I will bid everyone good night and thank you so much.
Thank you guys so much. It was great to be here.
Yeah, it was. Thank you all. Bye-bye.
Bye all.